I guess what the government would say, and I think is the most compelling argument, is that the Savings Clause specifically contemplates that a district court would have denied relief in an initial 2255 petition. And so the question is, having accepted that, what are the situations in which it would believe 2241 would come into play? And that is when traditional habeas relief would have been granted. Putting aside the petitioner's belief that it's the same as cause and effect, because I don't think so. I think miscarriage of justice stood on its own. I look at the words of the statute and see that it explicitly does not preclude traditional 2241 relief that includes cases that are defined as miscarriage of justices. I don't know that I need to find a reason why Congress didn't include statutory or not, why Congress didn't do it. It just didn't do it.
Well, Justice Sotomayor, I think the question then is just circling back to what negative implications are we reading from 2255H?
No, I'm reading the positive implications. 2241 does not preclude and has always included miscarriage of justice cases. Whether that's something that's come up in Davis or Bailey or after Congress wrote the words or didn't write the words, it just didn't preclude that explicitly.
So maybe this is a helpful way to frame this. The rules for second or successive 2255 motions used to be evaluated by, is this a miscarriage of justice, or would this violate the ends of justice exception? And what 2255H did was cut back on that by essentially codifying what Congress thought counted as sufficient miscarriages of justice. And so I do think that
But it didn't say that. It gave two examples and didn't preclude all the others that fell under traditional habeas.
And so then the question is, should the court read 2255's limits as just all being self-defeating to the extent that something would have been available
previously? But you're reading it right now in a way that gives no meaning to it at all, because I don't think you say it applies to cases that wouldn't be 2255 situations.
I want to make sure I understand your question. I think maybe you're saying a circumstance in which the saving clause would apply for a second filing. If
Yes,
that's what you
exactly.
mean. I think the circumstances would be just the same as when it would apply for a first filing.
Well,
but
the
for
problem is that those circumstances today would mean you wouldn't be in 2255 at all. You'd be in 2244.
So let me give an example that maybe will make clear.
2241.
There could be someone who filed a first 2255 motion, and then they are authorized under 2255H to file a second, but now it is difficult or impossible to get to a sentencing court for whatever reason. The saving clause would apply in that context just as it would apply initially. And again, that's the way that it applied historically. There's a much more concerning type of superfluity on the other side, which is that the saving clause really didn't do anything for 50 years except to lie in wait to spring into action and nullify a future congressional amendment. And that's really what the vision of the saving clause under both petitioner and the government's theory here is. I mean, I fully take the point.
Thank you, counsel.